Good morning, Mr. Beauregard.
May I proceed, Your Honor? Thank you.
You certainly may.
Good morning, Chief Justice Marshall and Justices of the Court. This case is Part 3, I will call it, of a third litigation that results from what I don't hesitate to say has been a systematic mishandling of long-term capital gains taxes that were decided upon by the legislature for the year 2002. Philip DeMoranville is my client. He's my only client in this case. In the Peterson cases, the two Peterson cases that this court knows very well, Mr. DeMoranville was a plaintiff among the others in those cases. The Peterson cases, as this court is aware, held that the tax was unconstitutional from a state constitutional point of view, Article 44, because there was not a uniformity of application to the various taxpayers. And it turned the matter back, as one would think it would, to the legislature in order to try to remedy the situation. What we are contesting here this morning is a response by the legislature, which is a horrible and illegal and unconstitutional fix, we allege, that has been applied. The problem is that the tax, while it was ruled unconstitutional, we believe that at that point in time it became nothing short of a debt that was owed, monies that were wrongfully confiscated.
You would agree, however, if the legislature hadn't taken up the invitation to change the effective date to January 1, 2003, and had left it at January 1, 2002, you would owe this tax.
Yes.
You wouldn't even get any refund at all.
That is,
right?
that is absolutely correct. The legislature saw fit to, instead of increasing the tax burden to the ones that didn't pay, which included a lot of very serious tax debtors had it done so, but it decided to alleviate the tax, and that's a judgment that it made.
So the refund is statutorily based. It's not constitutionally based. You're not constitutionally entitled to this refund.
We say that we absolutely are entitled to a constitutionally to a refund under the circumstances where there was an adjudication that the money was owed and that there was an illegal and unconstitutional tax. At that point in time, with the legislature's best judgment on how to remedy the situation, it then perpetuated the unfairness, if you will, that had earlier been argued and now turned it even into a further constitutional problem by again depriving the people who had paid taxes of the interest on the monies. The legislature, by doing so, we believe has set a very dangerous precedent, if you will. If this act...
So what's the remedy? What's the remedy?
The remedy is to pay interest to the...
So what should this court do? Order the legislature? Order the treasurer? How would we do it?
We don't believe that this court has the authority to order the legislature to do such a thing.
So that's not an option.
No, but there are things that the court can order the legislature to do, and also it can declare...
For example?
To declare the statute unconstitutional, and one would hope that the legislature would take the pronouncement of this good court seriously and do what's right.
The last case I argued in this court, the court declined to accept that argument, so we can perhaps be overruling, I think it was called Massachusetts Taxpayers Association, where we declined to do that. You're asking us to overrule that?
We are not asking you to overrule it. We are asking for an appropriate order whereby the legislature would be directed, and I can't say that I have the exact remedy or the exact language that I would suggest to this court, but I would think that the court does have various alternatives available to it to encourage or even order the legislature to do certain things. I think there was one...
Well, in the words of the colloquialism, did your clients have to pay to play? Were they required to pay the tax in order?
Absolutely.
They were?
Yes.
No, hasn't that rule been changed, the pay-to-play rule?
Don't know.
In other words, could your clients have simply
Challenged.
not paid the tax and challenged?
Well, we're talking two different stages. All of that is water past the dam, if you will. It's Peterson 1 and 2 dealt with the payment and whether it was paid or not. We are now dealing with the remedy that
Let me ask you this. Let's assume for a moment that the Commonwealth decides that a special tax that it imposed last year, it was imposed, it was collected, but in retrospect, unwise. So it not only repeals the tax, but it enacts a statute saying everyone who paid the tax last year will get the money back, but
Yes.
no interest.
Yes.
Do they have some sort of right to get interest?
I say no problem. As long as the original tax that was assessed is something that was not a mistake and something that was illegal and unconstitutional.
But if the legislature had said in this case, we're going to stick with January 1, 2002, there would be nothing illegal about it.
It's illegal because it perpetuates the difference in treatment to the different taxpayers.
You just said to me, because this court said, legislature could choose to make this law effective January 1, 2002. If it had, your client would have paid the tax, would get nothing back.
Right. But it would have corrected the unconstitutional discrimination that occurred in 2002 when it imposed the burden on some taxpayers and relieved others. And one, for example, was a well-known sports team in town that happened to fall into the period before that.
That's irrelevant. But could I just
No,
ask
but-
you this question? Why don't you have to exhaust? The appellate tax board can rule on, if you're right on the constitutional question, why can't the appellate tax board take that up and deal with it?
Because the statute in this case is absolutely explicit, and it tells the commissioner and whoever would hear the commissioners, review the commissioner's action, the appellate tax board, that it will not pay any interest. It's in the statute, it's explicit.
But you're saying that's unconstitutional. So the appellate tax board says, can't do that. It's unconstitutional. You, Commonwealth, has to pay interest. I think they've got the power to do that.
I would submit to the court that the appellate tax board, composed of whatever composition it is in the scheme of government, does not have the authority to look at the legislature and say, when you say without interest, that's unconstitutional.
But even if that's true, where the legislature says that this is the exclusive basis, this is the exclusive remedy, why aren't you required at least to go through the appellate tax board and have the case decided in an appellate court? Because,
Your Honor, of the delay, because of the energy and expense that would be involved to the taxpayer in trying to reclaim monies that belong to them.
But there's going to be an appeal in any event, isn't there?
There'll be an appeal, but it may be 3 or 4 years hence, or more possibly, with various stages. There'll be the process, think for a second, will be first the commissioner, then the appellate tax board, then the appeals court, and then perhaps presented to the justices of this court. The time and the expense, we say, runs this case into a federal constitutional problem, because not only is there a problem with depriving people of money, but there's a problem with giving a remedy that does not involve undue and unreasonable delays. And that is a federal constitutional right. You can't have your property taken and then not get it back with an adequate remedy. And here we get into an inadequate remedy
Mr.
where so much
Beauregard,
time is involved.
I'm sorry.
No.
Could you, the Attorney General has drawn our attention to an recent Oregon Supreme Court case that seems to be almost directly on point, the Pendle case. I know you didn't file a reply brief. Did you have an opportunity to look at that case?
I have not, Your Honor.
Okay, because that raised both state and federal constitutional arguments for the failure to pay interest where there had been a declaration that a taxing statute was unconstitutional.
I am aware, and I've footnoted, and I'm happy to say, because it comes from a Cleveland source, which is my daughter in law school, that there was an Ohio Supreme Court case decided as this case was pending that dealt with monies that were owed back to people that hadn't claimed it. I think they were bank accounts. And the Ohio Supreme Court said that the state constitutionally had to provide interest together with those deposits. The adequacy.
If that is a recent case and if it is relevant, I think it would be appropriate to file a Rule 16 letter with that citation if you have it.
The citation is in the footnote,
Oh, I'm
Your Honor.
sorry.
In my brief, Michael, if you can find that.
That's fine. If it's in there, I just
But
I can
it is
see
pointed out. It's footnoted.
Now, how can you say it's futile to bring the matter before the appellate tax board, where in Lonstein, the appellate tax board did find that the tax was unconstitutional?
I'm glad you asked that. The Lonstein case, first of all, involved a voluntary act by the petitioner to go through the tax board. In this particular case, neither Mr. DeMoranville nor all of his other Peterson co-plaintiffs filed with the appellate tax board, and there's a very good reason. They could read English. They could read the statute that said no interest, no interest. So they thought reasonably that it would be futile to try to get the commissioner or the appellate tax board to deny what the legislature had directed in that case. Besides that...
But in Lonville, the legislature clearly said that we're going to tax savings deposits, depending on the amount, differently. That was equally clear.
I would like to say that the Lonstein case, and I'm not denying that it is not an example of a case of a petitioner that went through the process and got the court, I should say, the appellate tax board to say it's unconstitutional. But what I would say, besides the fact that the petitioner chose to go through it, is not for 1 second did Lonstein deal with the issue of whether or not the appellate tax board should be making such. That wasn't briefed. It wasn't argued. But it was in the Duarte case. And the Duarte case came some 15 years later.
But what the court said in that case was appellate tax board can't declare a regulation invalid of another agency, but it can say, as applied to this particular case, that it would be unconstitutional. And wouldn't that be the argument here? That as applied to your client, your argument would be, this no interest on refunds is unconstitutional.
No, well, yes and no. It's facially invalid. That's the argument that we're making. We don't need any particular expertise of the appellate tax board to say, as applied to this case, because DeMoranville is this or that, it is facially invalid. The commissioner and the appellate tax board, if they were to follow the law, had no authority, no discretion to do anything other than to tell Mr. DeMoranville, sorry, take your appeal through the appeals court or wherever it's going to go. And that is brought out in the Duarte case, Your Honor, just before, at least on my thing, on paragraph 14. It says the board had the authority to regard the regulation as invalidly applied to the case before it and could probably hear and consider the evidence that Duarte was barred from presenting at the hearing. But then it says the board, however, lacked the inherent or common law authority to strike down the regulation.
That's my point. They could apply. The board could say in your case, Mr. DeMoranville, or to the commissioner, it is unconstitutional to not award interest to this taxpayer.
As applied to you, but then the appellate tax board would be treating one taxpayer differently than all the rest that didn't
Not the board's
apply.
problem. That's not the board's problem. It has a case in front of it.
My point there, to the extent that it's the right thinking, is that there's a facial invalidity. It says no interest. It's absolute. It doesn't apply for any discretion of any kind. Before I forget, I should point out to the court that the last time this good court decided an issue on interest on taxes was in 1893. And that's the bad news. The good news is that there have been no changes in that case. And that is the Boot, if I get it right, the Boot Cotton Mills case, which very explicitly held that, Boot Cotton Mills case, that that interest had to be paid on taxes that were illegally taken.
Is it your view that whenever the Commonwealth commits a constitutional violation, it is obligated to pay interest, even if the legislature explicitly says that it shall pay no interest?
The answer is yes, if the money is exacted in a way that's found to be unconstitutional. And here's where I would suggest to this court that this case is something that is of great interest from a policy point of view, from a recurrent point of view, from a fairness point of view. Why couldn't the legislature pass statutes in the future that found some other way of getting people's money, not necessarily intentionally, but something that was later held to be illegal, unconstitutional, and then say, okay, well, we've learned our lesson, but we're not going to give it back to you with interest?
And if we accept your proposition, would it then go on to say that with regard to constitutional torts, that any statute which would bar the payment of interest would be equally unconstitutional?
If the premise and if the basic finding is a mistake, if it's illegal, if it's confiscatory, and all of those bad words I can ascribe to something that the legislature shouldn't have done. And here they didn't on a constitutional basis. The answer is yes, that does amount to due process. It amounts to taking of property. The appeals court in a case dealt with the matter of interest in eminent domain cases. And the analogy, I think, on the level that you're asking the question should be drawn from that case. We believe, in conclusion, Your Honor, that, again, I don't want to give up the matter of precedent and ask you not to overturn the 1893 case of Boot, Cotton Mills, but from the point of view of a very important recurrent problem, potentially recurrent, don't let the legislature take money from people, have it ruled unconstitutional, and then to say, okay, we'll give it back in 4 years' time and we're not going to pay interest.
Thank you.
That's not what this court should sanction.
Thank you, Mr.
Thank you very
Beauregard.
much.
Good morning, Mr. Barnico.
Good morning. May it please the Court, my name is Thomas Barnico. I'm an Assistant Attorney General, and I represent the Commonwealth and the Commissioner of Revenue in this case. The Court should affirm the judgment of the Superior Court. After the decision of this Court in Peterson 2...
How can we do that if you say that the exclusive remedy is the Appellate Tax Board?
You would affirm the judgment that Judge Fabricant entered dismissing the case for failure to exhaust administrative remedies.
Oh, okay, I'm sorry.
And alternatively, the Court, if it declines to accept any of the reasons articulated by the Superior Court, it could reach the constitutional claims against the denial of interest and affirm the judgment nonetheless, because each of those claims fails to state a claim upon which relief can be granted.
Well, why should they have to go through all of the steps of exhausting the administrative remedies when the legislature said no interest?
Well, for two reasons, Your Honor. First is because, as a matter of statute, and as the Lonstein case demonstrates, the Board is authorized to grant the relief involved. But there's a more important reason, I think, involved with the facts here and the chronology that demonstrates why we must require taxpayers to go through the administrative process, so to speak. And that more important reason has to do with the legislative process that's been established for the payment of money to taxpayers who have shown that they are entitled to pay less. That is, it's been made clear by this Court that whatever the right of a person to seek a declaration in the Superior Court or the SJC for Suffolk County in a tax matter, the right to receive money that might flow from a successful declaration is always dependent on the requirement that a taxpayer keep alive their right through the administrative process, their right to obtain money. That's, we say, is in the Perini case and the space building case. And Judge Fabricant noted that line of cases in footnote 5 of her memorandum and order. So that is why we must require that people preserve their rights and preserve their claims, so that in every case we're aware of in which this Court has permitted a declaration to be entered, an exhaustion not to foreclose the declaration, it has always required people to keep alive their claims, to so to speak, cash their declaration at a window which represents the waiver of sovereign immunity that the legislature has provided for successful plaintiffs of that type.
Because
Now
other-
here,
we were to
that's
do
where
that-
this is interesting here on the facts, is
Could I
that
just ask you a theoretical question? Because theoretically, if that opportunity isn't kept open, theoretically, then this Court would have to order the legislature to pay it? Is that what would have to happen?
well, that would present a
I'm not saying, you know, does
Questions?
that present other problems, but mechanically, isn't that what would have to happen?
mechanically, what it would present then would be the question whether a refund is required as a matter of due process or some other aspect of the state constitution.
And if there's no, and I think the import of Justice Botsford's question is if there's no alive claim in the ATB, then we can't remand it back asking the ATB to do something that is consistent with the opinion. Then we are in the difficult situation of then we're back to what I think is the mass taxpayers case, that we're just being asked to declare something unconstitutional and hope that everything follows, but there's no alive issue at that point.
Right. I have two responses to that. I think within your questions is the further important constitutional questions, whether as a matter of due process the taxpayer be entitled to anything at all. You're
yes,
positing the declaration, and then the question comes, as a matter of United States Constitution or state constitutional law, whether the state must give meaningful backward-looking relief, and it would only be then, upon that judgment, that a
Correct.
confrontation would
Right.
exist.
Correct.
Yes.
Yeah.
It just so happens here, though, that, and the other aspect of your question would have to do with the mootness of the request for declaratory relief. In my view, the footnote that Judge Fabricant, in which he discussed the question of whether monetary relief could be awarded by the court, might have stopped one step short. That is, if you accept the fact that these taxpayers, like any taxpayer, must maintain live claims for money in front of the commissioner or the board, or make them within the time limits, say, after a successful declaration, then the declaration in this instance isn't operating on any existing controversy. If they are required, as we say they are, and we think the court has said, to maintain their claims in some live way or make them later in a timely fashion, then the declaration itself isn't operating on any real-world event. And so that would be an alternative ground here. Of course you can affirm on the ground that you apply the usual factors that concern exhaustion in tax cases. You decide that it was not futile to go to the appellate tax board, that this issue was not recurrent. You could do all of that and affirm. But if you have doubts about the ATB jurisdiction, you could also affirm on the ground that they couldn't get a money judgment out of the Superior
Could
Court.
I ask you, this is a sort of the statute of limitations. I don't really understand as a practical matter. The payments are coming in four times. The last, I take it,
Yes.
in this case, was 2009.
Yes.
So is there a statute of limitations that runs after the payment, or was the last place that you could do this, the later date in terms of the 2005 statute is 2006? What's
latter,
that-
06.
It's the latter?
June 06.
That's the last time that, because all the other opportunities related to when you paid the tax or when it was assessed. Is that right?
Yes, I think it's fair to say that it would have all played out within 06, because it would have been payment of the tax, not the acceptance of the refund. Although, on this record, it's interesting that the plaintiff didn't even take advantage of the successive payments of the refund to perhaps raise a hand, timely or not, and say, what about the interest? It was only March 08 that this complaint gets filed in the Superior Court, leading to a record, I think, which conclusively establishes that all the past periods are past. Now, there's a third.
So basically, if we affirm Judge Fabricant, they're out of luck. They're too late even to go to the ATB.
Yes. And in fact, what I'm saying is that's a further reason why you might say declaratory relief in the Superior Court in this case is improper, which is surely the bottom line of the Superior Court judgment.
Because there's no case of controversy.
Yes.
Was it also too late at the, if a petition had been filed in front of the appellate tax board on the same date that the Superior Court action was filed in, I think, 2008, would that have been too late as well?
I believe so, Your Honor. I'd have to go back and recalculate each of the time periods set forth in Section 37 and adopted by the 2005 action of the legislature here, but I believe that's so, and it may be why they went to Superior Court. Now, still on the question of the threshold grounds for dismissal is another ground cited by the Superior Court judge, and that is the reference to the word exclusive in the 2005 statute. She seemed to think that that was either very strong point in support of the denial of declaratory relief or bordered on the denial of relief as a matter of law, that in this unique circumstance, the legislature was intending to foreclose the declaratory relief that has been granted by the court in the development of case law since the Declaratory Judgment Act. So that could be another ground on which the court could decide the case, was that in this instance, on this specific statute, in these unique circumstances regarding the refund of the Peterson payments, the jurisdiction of in the administrative process was exclusive, and relief under 231A was foreclosed.
I take it that implicit in that is that the legislature intends to enact constitutional statutes, and that so even if one had some concerns that Longstein wouldn't apply here, this would be not only an affirmation that declaratory judgment was being ruled out, but because you can never prohibit a citizen, a resident, from all access to relief, that the legislature was essentially saying, go there.
First.
First.
Yes, because of course nothing in that reference to exclusive.
And so if we had said, no, you can't go there because the ATB, for the reasons articulated by Mr. Beauregard, cannot consider these questions, then we've created a real mess, right?
That would cast a certain line of cases regarding the jurisdiction of the Appellate Tax Board in doubt.
Right.
That's right.
Mr. Barnacle.
Whereas here, affirming on the statutory ground that Judge Fabric identified would avoid that question. In addition, on that question, it's important to point out that the reference to exclusive means, in the first instance, it wouldn't mean to displace the ordinary appeals.
I understand that.
Mr. Barnacle, a couple of years ago, the commissioner was here very aggressively arguing that the ATB had no power to strike a regulation. Presumably that would mean a statute as being unconstitutional. The court agreed in the Duarte case. Isn't that essentially what the ATB would be asking to do, would be asked to do if taxpayers were forced to go before the ATB?
No, Your Honor, and in fact, Duarte, in the decision of this court in that case, is consistent with our position here for this reason. Duarte anticipates, I think, the case in which the board could grant an abatement on the ground that a regulation of the commissioner is facially inconsistent with the statute. Now, that's not a declaratory ruling in the way the court understands it, as an action of the Superior Court might be. It would have only stare decisis effect within the board, but to be consistent with Duarte, because it would be no declaration, but rather relief granted to an individual taxpayer on the ground that that tax was illegal within the meaning of Chapter 62C.
The
Section
tax was
37.
illegal? Or, I mean, I take it the taxpayer is going to be looking for the tax and the interest, and the board is going and make the claim that the statute is unconstitutional to the extent that it says the interest shall not be paid.
Oh, I was not intending to limit it that way. Those cases could sometimes
And the ATB says we can't strike the statute as
But
unconstitutional.
I think what you would say that Duarte would say is that we can't strike down the statute, but we can say, as applied to
Every
this
taxpayer.
particular taxpayer, it would be unconstitutional not to award him interest.
Right, or again, I focus on the statutory term, which is illegal, from which the power of the board flows. But exactly that, and that was exactly the ruling in Lonstein. That is, the taxpayers before the board brought a claim that a statute that quite clearly distinguished between bank accounts below and over $100,000 violated Amendment Article 44, the tax on them, different rates. And so relief in that case was granted to that taxpayer. Now, That is not, again, a declaration as the court understands the operation of trial courts. It has stare decisis within the board. The commissioner could expect to lose the same case brought the next day, but it doesn't have the same power of contempt or statewide application or some of the other things that flow from the Declaratory Judgment Act.
Now, why is this different from a taking? I mean, with regard to an eminent domain taking, does
Yes,
the Commonwealth have an obligation constitutionally to pay interest?
Yes, Your Honor. I think it's different because of the specific reference in the Constitution to just compensation. And it would flow from, and I know the court has considered that term in a question about interest on a judgment in an eminent domain case. And I think the position and why the court could distinguish that from this instance is that there it was deciding that case under a different and more express in constitutional source. Here, there's nothing in Article 44 that mentions interest. We found nothing in the history of Article 44 that specifically concerns interest. One last point on history, and that is the reference to the Boot Cotton Mills case. That case is cited in a later opinion of the justices. We can provide by letter, but it's 356 Mass. 751, 1969, cites Boot Mills and I think casts some doubt on the plaintiff's theory of a overarching constitutional right to interest in a tax case.
Well, are you, and I notice you did not cite the case, Boot Mills case, in your brief. Is it simply not relevant to our analysis of this problem?
It's an opinion of the justices, and it's not quite clear what.
Well, the Boot versus Cotton Mills case is not relevant.
I don't think it's a constitutional case, Your Honor. It's cited by the opinion of the justices in reference to a constitutional issue, but I don't, as I say, don't think it stands for an overarching right that the plaintiff has asserted. Thank you very much.
Thank you, Mr. Barnacle.